Welcome. Thank you, everybody, for coming in and joining us for this, what should be a very interesting conversation around exploring what employee ownership by trust does look like and might look like for law firms in Australia. And we'll be looking at, so I'm just looking to see who's coming in. Welcome, everybody. So we'll get started right now. So welcome. My name is Jana de Wilder, and I'm from a company called Mills Studios, and we are the first Australian-based organization to take on employee ownership by trust. And today I have the great fortune of being the facilitator of a conversation with Jessica Mitchell and with Luke Geary. And today we're going to be exploring what it looks like to explore employee ownership by trust within law firms, legal firms. And Jessica will be telling us a story and some experiences about what that looks like in the UK with an organization that she's been working with. And Luke will help us to explore what that might mean in the Australian context. So what I would love to do, I know webinars feel very distant sometimes, and what we do want to do is open this up for conversation after we lay some foundational stories and some provocations for all of us. So please feel free to use the chat, and if it's relevant at that moment, we'll bring that into the conversation then, or we will open it up for a broader conversation. What I would like to do, just as an acknowledgement of country, is acknowledge that we're all coming from different parts of Australia and maybe from even other different lands. And so as we're gathering in this very dispersed and virtually constructed space, we'd just like to acknowledge the lands on which we are all standing and acknowledge the leaders and knowledge holders of those lands, past, present, and emerging, and pay our respects to their ancestral spirits. Thank you for that. Okay, I'd love to explore and first introduce our speakers. So Jessica, could you give us a bit of an introduction to you and your perspective?
Sure. So I am qualified as a lawyer in the UK and Australia. I work in employee share plans in legal and tax compliance. Shall I talk a little bit about Tapestry now?
Yeah, why don't you do that?
Yeah. Okay, so Tapestry is a boutique law firm which is based in the UK. I should say now I'm based in Australia, and I'm not actually an employee of Tapestry. I'm a consultant, but I have been with Tapestry since it was founded in 2011, and they have given me permission to share their story for this webinar. So Tapestry specializes in global employee share plans. We have clients that are headquartered all around the world. We help them with design, documentation, bespoke advice for their share plans in many different jurisdictions. We have an online subscription database which covers legal and tax compliance for about 150 different countries. It's an award-winning law firm, and it's Tapestry is top ranked in both the UK legal directories. Our sole focus is employee share and incentive plans, and Tapestry did become employee owned itself, obviously by trust, in 2020. So in 2020, the founders sold the firm to an EOT, and it's now 100% employee owned, and we're going to talk a bit more about that.
Amazing. Thank you, Jessica. Really looking forward to hearing that story and reflecting on what that might mean for us in Australia. Luke, can you introduce yourself and the perspective you're bringing?
Thanks, Jenna. I'm also a lawyer, and I am presently a partner of a law firm called Mills Oakley, which is a large Australian commercial law firm of about 1,000 people around the country. But I became a partner in 2009, and 7 days later I quit the partnership to start a free law firm for the Salvation Army, which was a social enterprise model, and it was called Salvos Legal. I'll bring to the discussion today, not quite an EOT perspective, but a very relatable perspective, I think, in terms of a lived experience of running a law firm in Australia, which was not a partnership for profit. It was one where we were effectively custodians for a charitable organisation. And so we'll talk about that a little bit, and how some of the dynamics I think that I observed in people, clients, practices, and broadly culture might predict how an EOT environment might work in Australia within the legal profession. These days, I run a practice at Mills Oakley, which is in fact a for-profit practice, although it's titled Not-for-Profits, Human Rights and Social Impact. So yeah, I get sort of the community that we're talking to today, and definitely am very aligned philosophically. Great.
Thanks, Luke. And I'll just note that we do have Andrew Clements on as well, who is the chairperson of EOA and can bring a lot of experience into how we've established EOT in Australia. And would you like to say anything, Andrew, before we get started? Just to put you on the spot.
No, look, I'll try something different. I'll try quietness.
Well, we'll throw to you when it's appropriate in case you missed the cues. So
no, all good. Thank you.
Thanks, Andrew. And just to give a bit of a context to EOTs, I'm assuming that there may be people on this that aren't quite clear what an EOT is. And so just I'll give the very sort of layperson's terms around it. What an EOT is that a trust is set up. So you have a trust company that is set up, and the trust holds the shares, holds the equity, the majority of the shares in the operating business on behalf of and for the benefit of all employees. And so this model has seen an enormous amount of growth in the UK. And because of that, we'll hear that story from around Tapestry's experience with that and their rationale for going to that. But just want to give you a bit of a sense around what that means. And to become an EOT, while we won't necessarily get into the nitty-gritty details of becoming an EOT, we will absolutely be touching on what it means to make a decision to become an EOT and what that means in terms of both, I guess, the technical legal structures in your organization, what the financial implications might mean in terms of buying those shares from owners. But most importantly, really start to dig into what are the cultural implications for organizations that do choose to take this path on. And so it'll be really interesting for us to kind of dig into how those things intersect, how ownership and mindset and culture, and what does that look like then when you look at sort of the traditions of law practices and how those are structured and what it means to have ownership or have equity or have partnership. And so those are the things we really want to tease into today. So we'll start with really looking at the case study of Tapestry, and thank you, Jessica, for getting that permission to share this really unique story, and it's something that I think we can learn a lot from. So you've given us a little bit of a sense of Tapestry's business and how they're structured. Can you talk a little bit around what does it mean for Tapestry to be an EOT in terms of structurally, and maybe how does that contrast to maybe some of the other traditional law firms you've either been in or that you know of?
Yeah, sure. So okay, so for a traditional law firm, we have, I think, a very clear hierarchy where you have equity partners at the top, and those partners own the firm. And becoming an equity partner is generally a long, hard slog, I think, for and then you have your lawyers and, of course, your administrative staff, and yeah, and again, there's a clear hierarchy and levels that you move through. The way, I mean, Tapestry has been structured a little differently from the outset. I mean, we still had our 2 founder partners and then you know, the standard staff, but I think it was set up from the start to be a little bit more dynamic and flexible. The way it works now in terms of the trust is that there is an operating company which runs the day-to-day business. I think under the UK framework, there are certain criteria that need to be met, but then there's flexibility within that. So you don't need to have the trust 100% owning that operating company, but for Tapestry, it does. So there's no individual personal shareholdings anymore. It's the firm is 100% owned by the trust. All employees are a part of the trust and they are immediately upon joining. And when they leave employment for any reason, then they are no longer a part of that trust. So they're no longer an owner. So the trust itself is managed by trustee directors. We have a founder director who is there to represent the founders. There's an independent trustee who brings sort of wider experience from the field, EOT expertise. And then there are several employee directors. And so any employee can put their hand up to take on a trustee director position, a role, and those are fixed terms, but they can be renewed or rotated. But so any employee, whether they're full-time, part-time, senior, junior, legal, administrative, it can be all different functions of the business, and can become a trustee director. And there is a range of employees represented at the moment. And then the actual firm itself, the operating company, is completely run by the employees as well. And there's a variety of business leads. And that was sort of, that's evolved post-EOT, but that was also set up well in advance of the EOT as well.
Excellent.
So that's how it actually works in practice for Tapestry. But, you know, that there is a lot of flexibility in how it can be set up and, you know, how it would work for different organizations as well.
And one of the core things maybe to touch into that part, Jessica, is around one of the key tenets of EOTs is having an employee council and having that employee representation. And so can you talk a bit about, in practice, well, I guess in theory, that the idea of an employee council is to create influence and around the decision-making around the business. And sometimes when people hear that, they think, oh, does that mean that the organization is now running by, 1,000 cooks in the kitchen, so to speak? Can you talk a little bit about maybe how, what that looks like in terms of decision-making and influence in terms of employee engagement?
Yeah, absolutely. And that's right. It's not as if, so there's currently, I think, around 23 legal staff and maybe a dozen or so administrative staff in Tapestry, and the firm is growing as well. We have more people joining. So it's not like there's sort of 30, 40 people making every decision. There are business leads, directors of the actual operating company of the business, and then people who, a variety of people who lead different areas, say different areas of expertise or particular functions of the business. But I think in terms of, decision making, it's definitely much more widely distributed than it would be in a traditional law firm. And I think that's, it's really representative and it's nuanced. We have the trustee directors and then the business leads. And again, Tapestry was set up where employees had a lot of ownership over those roles even before the EOT. And that, I think the EOT structure has just cemented that. But yeah, all employees have, any employee can be considered for a lead role either in the operating company or in the trust. And I think that that's led to definitely a lot of employee engagement. I think it's really representative, and we have a lot of agile working arrangements. I mean, I've worked, from Australia on the other side of the world for 10 years, so that's not just discussing, but I think that's, really, we have people who, everyone I think has a really full life outside of their career at Tapestry as well. And I think that having a range of different employees in decision-making roles has really contributed to that.
And I think you're touching into sometimes, I guess, there can be a misconception that if you do become an EOT, that means that you necessarily are going into a really flat structure. And as you were saying, it's actually really a choice in terms of there's some things that are core to being an EOT around employee representation and counsel and influence of decision making, but you can still have those areas of responsibility, and you get to decide as an organization around what kind of hierarchies you might still continue to have in terms of how you run your business. So there is a lot of flexibility there. Can you give us a sense of around, I guess, with that flexibility in terms of the EOT does lend itself to encouraging and supporting from an ethos point of view, different ways of being and different ways of working. Can you talk a bit about, I guess, that gender equality piece? You know, I guess historically, the act of getting partner can be quite a slog, as using your words. Can you talk about maybe how that plays out in practice in terms of giving more people more access to opportunities?
Yeah, and I should say, as you said, with having a completely flat structure, that's not the case. There are still leadership positions and roles, and for Tapestry, and again, this can be different for other organisations, but for Tapestry, there's no obligation or expectation to take on any role outside of your normal day job. So you can do, and I guess the level of involvement and engagement in the fact that it's employee owned in the trust is voluntary, and it's part of, there are structures which were set up pre-EOT, and I think that they will continue to evolve as the business grows, as new people take on different roles. And but there is no, I mean, employees, for most employees, it's business as usual, and then there's that additional level of engagement. And in terms of gender equality, I think it's and it's something that we've talked about, and I don't think that there would be any studies as yet or sort of solid data around this for EOTs or even employee-owned companies generally. But I think as a concept, and from what I've observed, that it really makes sense that let's say that historically in a traditional law firm, you need to have worked really hard for a number of years and to have built up a certain client base in order to become an equity partner, and to be chosen to be an equity partner by the existing equity partners. And if you've taken time out for any reason, or if you work part-time, then that's a serious disadvantage. And the reality is that would typically affect women. And that women often do take some time out when they have a young family, or look for more flexible working arrangements when they have a young family. And that can put them at a disadvantage with their male colleagues who have also had a young family in that time, but haven't taken that, haven't had the same caring duties. So I think, just having the leadership more widely distributed and having a variety of people and who do work in all kind of different arrangements and who have different individual circumstances, I think that necessarily leads to a downstream effect of being more family friendly and just being more accommodating of all kinds of circumstances. I mean, at Tapestry, we do have people in lead roles who work part-time, and it's always been a female-led business. So again, a little unusual in the legal industry. But, we also have someone who is competing for Britain in the World Hang Gliding Championships. We have another elite athlete, someone who's a yoga instructor, people who have different arrangements. And I think with the way that it's set up, that, it's really acceptable and encouraged to be able to juggle a full life with a successful legal career at a top firm.
Amazing. I guess maybe two things to close out this particular part of the conversation. So one is around the concept of succession planning, and we know that for a lot of organizations that are founder-led or partner-led, there is that question around the longevity of the organization and what that means to sort of pass the torch. And I guess it's fair to say that in legal firms, there have been sort of historical structures that have helped to support that with partnership and with equity. Can you talk a bit about, I guess, what it means now to be 100% employee owned, and now that succession question or worry or concerns not actually there for Tapestry, and what does that mean? I guess does that take pressure off of the organization, or does that create a different kind of sense of being without having that as a pressure?
Yeah, I think so. And I guess, again, I'm looking at this I'm observing from afar, and I'm not actually an employee, but talking to employees before this webinar. And from what I have observed is that there is a real sense of longevity of the organization and of the culture, and of, planning long-term for the future. A quote I really liked from one of our amazing secretaries was just, "It feels like our money now." From one of the lawyers was, what did she say? She said, we have a real the ability to shape our future going forward. Yeah, and I feel like that's broadly the sense, that people really do have a genuine sense of ownership and of agency over the strategy of the firm, the operation of the business, and just the future of it. And I think that's, yeah, and of course I can't speak for everyone, but I think that there's a very distinct culture that's come from being an EOT.
Thank you for that. I was just about to introduce Luke into the conversation, and we've seemed to have lost him. So we will continue until Luke comes back. So maybe a bridging conversation between your experiences with Tapestry and your observations of Tapestry, and then thinking about what that might mean in the Australian context. I'm interested in your thoughts and reflections, Jessica, about the advantages and disadvantages of being EOT, I guess, in the marketplace, and with clients, and with attracting work, and with how perhaps the law firm is perceived. Does it become something that actually impacts, from your perspective, how the work is actually done out in the market?
Yeah, I think that's a really interesting question, and that could be, and that's something again for I think Luke's to speak to, in particularly in the Australian context, and for a more traditional law firm, because I think that could be, we know that there are now over 1,000 EOTs in the UK. Only around a dozen of those are law firms. And I think that's a really small proportion, because there are a lot of other professional services firms that have moved to an employee ownership by trust structure. And I think, that's because, well, probably one of the main reasons is that the legal industry is still, primarily a traditional, conservative, I guess less dynamic industry. And part of that might be client perception, and also staff perception as well. And I think Tapestry has been, I think, much less affected by that than most firms would be. And the reason that Tapestry already was a fairly, I guess, groundbreaking firm in the sense that it was a boutique firm based outside of London, relatively young. The people that do our work, share plans for major companies would typically be the London sort of Magic Circle or Silver Circle firms, or the Big Four accountancy firms. And, so the people that we work with, we already had an amazing client base, and people that we work with are people that do employee share plans and do employee ownership. So I think for our clients, it was a really positive reception, and a feeling that, that it was in line with what Tapestry does. So I think that, but I don't think that's really representative of the average law firm, either in the UK or in Australia.
Thank you for that. And a question has come through around just asking for reflection on the extent the tax concessions are driving the uptake of EOTs in the UK. I'm not sure if that was something that was what led Tapestry to choose EOT, but certainly later in our conversation, we can certainly, I see Andrew Pendleton is on the line as well. And Andrew maybe can comment more broadly about that uptake in the UK. But I guess specifically with Tapestry, what are your thoughts, Jessica? Is that something in terms of the drivers for choosing EOT over other forms of employee ownership, or?
It might have been a factor, and I really, I mean, not being one of the founders, and I think that they considered all the options, probably like Mel did, and I think the EOT is it's a really solid form of employee ownership, and I think that had always been envisioned by Tapestry, some form of employee ownership. And probably one of the main benefits is that it doesn't carry a lot of risk, or any risk really, for the employees, the way that other structures might, or other transitions might have. So I think that, there's all these benefits of being employee owned, and then without much downside. So as to how much the tax concessions made a difference to the Tapestry founders, and how much they would make a difference if we had something similar that was introduced in Australia, I really couldn't say.
Oh, good. Well, we can come back to that point as well. Welcome back, Luke. Are you able to
Sorry for that hiccup, but
Nope.
I've demonstrated I'm agile.
You are agile. I appreciate that. So why don't we thank you for that, Jessica, and please feel free to jump in with your perspective, as we're also talking to Luke about what this might look like in the Australian context. So Luke, with your experience in terms of that social organization that you were a part of and were leading, and how the elements of actually being in that were quite similar to what it might look like or feel like to be in an EOT. Curious about your reflections on, you've heard Jessica's story around Tapestry, you have a sense of what EOT means, and you also understand traditional law firms. What are some of the advantages or disadvantages that you see there might be to being an EOT-owned law firm in the Australian context? So maybe we can start with you can use your anecdotes and your stories to play into that.
Sure. So I think probably the first observation I have is what we call in Australia new law. That's the general theme that we give to non-traditional law firms in Australia, new law. New law is probably only about 10 years old, 10, 12, 13 years old. So in terms of how culturally the legal profession receives different models, still very, very early. And the UK has, in social enterprise, in general progressiveness, a several years head start on Australia. That cultural injection is a little bit delayed still. I can say that certainly my observations were that when I presented a model of a law firm which was unique, it was a social enterprise, it was strictly a commercial law firm, 100% commercial law firm doing 100% commercial law, acting for banks, government, mums and dads, businesses, all of it for proper market fees, who decided it wasn't going to give that money to the small handful of partners of it, but instead was going to take all of the money and fund a free law firm for people in need. That concept was so foreign, and anything that was foreign in a profession such as law, which is I think universally recognized as being behind the times, is anything that's foreign is feared. And I think probably my observation of doing something differently at a time when new law was still very conceptual was that my vision of how good it would be and how much it made sense for clients to take up and for staff to flock to, my naive enthusiasm wasn't met by the reality, which was really conservatism. The clients that I wanted to secure had a philosophical alignment with me that it was a good idea, but there was always something that was hesitating in terms of being able to seal the deal, in terms of becoming clients. And I believe, and I characterize it as something which I call the hack factor. And I'll give it this historical description from my own experience, but I'm not saying that this would necessarily apply to EOTs, because EOTs aren't charitable institutions butting against the legal profession, but simply because an EOT structure is a non-traditional structure, which is a little bit of an anathema to lawyers being, frankly, perceived as being greedy and wealthy and wanting to have the power in a concentrated group. The hack factor for me was if I was pitching to a client, for example, the Commonwealth Bank, who ultimately did become a client of ours at Salvo's Legal, I had to start from the presumption that because what I was presenting to them was different to the other firms that were on their panel, that it would be feared. And it was feared because I knew that they would be starting from the position that if this guy is any good, he's going to be at a large law firm as an equity partner. Why would he give that up for some altruistic purpose? It doesn't immediately connect to corporate Australia. And I don't think that that's that different to other corporate clients globally. And so for me, I had to persuade them that the brand of what I was selling was still of the same quality and alignment, leaving aside the social benefits that what we were able to provide. And in a sense, an EOT isn't too different from a social enterprise focused on employment opportunities. And so for me, overcoming that was a big thing that I never really presumed would exist, simply by virtue of the model that I was presenting to them. And it just sort of evidenced for me how conservative the Australian corporate legal clientele would be. But I can say, once I overcame that, the enthusiasm for the model of what I was presenting to corporate clients was very strong. And they thought, wow, this is a really great idea. It's different. It's not lawyers that we resent for as a necessity. It was something that was a little bit more of a feel-good transaction for them. And so I think there is opportunity within the Australian commercial legal services market for clients to engage with an EOT type model for a law firm. But I think there's a lot of communication and messaging and patience that would be required for the clients that, at a large scale clients that you would want to engage with, because you're butting up against 150, 200 years of traditional models.
And I think if I could just to reflect on what you've just said, Luke, and I think it's important to talk about, I guess, the spectrum of some organizations when it comes to being an EOT may wear being an EOT on their sleeve because it's very reflective both of an ethos and a culture and how they operate. And there's almost a brand association with what it means to provide equity and equality, I guess, to all employees and for everybody to have both a say, but also reap the benefits of the value that is created, the wealth that gets created from organizations that, part of the EOT is also in the sharing of that profit back to all employees. And there's I guess something there around, which I think is interesting to maybe reflect on in terms of, does that become a part of your identity and who you are and how you attract lawyers or other people who work in law firms to be a part of something like that? Or is it something that exists that is more of a we're quietly an EOT, but we have other ways to maybe perhaps play into the dynamics of I guess what it means to be a partner and how that gets rewarded. Maybe it's still there, but maybe it's not in the ways that it's traditionally been held. What are your thoughts about that, I guess, in terms of that spectrum of what that might
totally be? Look, it really depends on how you define your market. Your market for clients and your market for talent. Wearing it as a badge of honor would be a market differentiator, as mine was at Salvo's Legal, but it did come with the constraints that I was perhaps alienating or making very difficult some of the more traditional clients who weren't risk takers or who weren't values driven. And I think, in terms of alignment with clients, if you're going to wear the structure as a point of difference, then you will find like-minded clients. And it really depends on what sort of area of law you want to practice in, what sort of clients you want to work with, what sort of price point there will be. And so, if you are very much you want to be a pure commercial law firm, you want to get, the banks or the government on board as clients, well, you're going to have like what I had in terms of that hack factor presumption, because to a logical person in corporate Australia, giving away all your profit to your fellow employees and not concentrating it between the leaders is not a default starting point from logic. And so I'm not saying you won't overcome it, but you should presume that that's an obstacle that you've got to really focus on diluting, because it's not people's fault for having that presumption, and it will be either conscious or unconscious bias, because the person that at the bank, for example, who makes the decision to hire a law firm that is not, traditional, will by default be taking a risk on you. And that person has little to gain from that personally, because they're not going to get paid any more money if the law firm is not a failure, but they will certainly cop the responsibility for the accountability of a law firm that, for whatever reason, if anything goes wrong. And I think that's if you want to wear it as a badge of honor, and I'm thinking, saying definitely to this audience, I'm sure that's a wonderful driver for a structure change like this. You just have to appreciate that will be a default perception by some of the clients if you're going for the traditional legal client market. However, if you're wearing it as a badge of honor, you also open yourself up to a whole nother market who has no appetite and no interest for the traditional law firms. You open yourself up to be the lawyer to social enterprise or innovation or startups or all forms of perhaps more contemporary businesses. And there's plenty of money to be made with those. It just is a different market segmentation. It also, if you are wearing your EOT as an upfront brand issue or identifier, it will also inform which people will want to work with you.
And Jessica, were you going to say something to that?
Yeah, I was just going to jump in and say, I think that's absolutely right. Like that, a certain market base would be much more open to an alternative structure. But I think there is also just a level of, these are barriers that can actually be broken down. I mean, like your story with the Commonwealth Bank. And I think for Tapestry, I sort of alluded to it before, but I think it had kind of broken those barriers before it became an EOT. And maybe if it had been employee owned from the start, that would have been an additional layer of, maybe misconception. But yeah, I mean, Tapestry's clients had to take a risk with not giving their share plan work to one of the traditional law firms, one of the major law firms or the big four accountancy firms, and to do that. And I think there was a decade of doing that and building up this, this client base of major conservative companies who would use those large central law firms for everything else, to give that work to Tapestry, and then Tapestry became employee owned. So, I think that there were absolutely those barriers there, pretty much for the same reason, just that it wasn't the traditional model and the usual law firm that you would be expected to use. And then if you take that risk and it doesn't go well, then that falls back on the person who chose the firm. So I think Tapestry did have that barrier, but it was before becoming employee owned, and then by the time it did become employee owned. So, I absolutely agree there are those barriers there particularly if you want the banks and governments and major listed companies, but the more that those risks are taken, then it becomes a sort of tipping point where it becomes more normalized.
I'm going to open up to questions. Some questions are coming in, and so I'd like to thank you both, Jessica and Luke, for your reflections, and looking forward to even more reflections with some of the questions. One of the questions that's come in is, do you think EOT, being an EOT as a law firm, provides a greater flexibility to move away from traditional pricing models? Jessica, maybe I'll start with you just to see, has that impacted, I guess, your pricing, the traditional pricing model approach, I guess, from within Tapestry?
Sorry, I'm not understanding the question.
So So Andrew, I think the question was from you. Do you want to unmute and describe a bit of a background to that?
Yeah, certainly. I mean, I guess my question is, I mean, a traditional Australian law firm model has been based heavily on billable hours and charging based on billable hours, with clients who've had a desire to move away from it, but a reluctant, I mean, it's a tautology, a desire to move away from it, but a reluctance to accept it. So I mean, again, in a sense, really to Luke's question is, did that give greater flexibility, and was that flexibility in pricing, the ability to present a different way in pricing, an advantage, or something that clients couldn't quite get their heads around?
Yeah, if I could answer that, I think it does give an incredibly more open amount of flexibility, and that certainly was our experience. However, there was obviously a reality in terms of keeping the lights on. But you know, where you do have employee-owned models, there's still a degree of responsibility of what's going to be an acceptable reward and recognition for the collective ownership. So it probably would be informed by the strategy of what distributions are going to be made to people, and in however form that might be. Whereas in my environment, it was really, I only had to remain sustainable, and in terms of our margin squeeze, it was really informed by our growth strategy, which could be dialed up or dialed down, having regard to the market conditions. But certainly, I think that is a more flexible approach insofar as, you know, we had the bigger picture in mind always, rather than any personal gains.
And it sounds like, and I think that's one of the things that we've experienced at Meld as well, in terms of the shifting to the concept of the collective over the success of the individual, and I guess the collective contribution to the organization, and not to say that we don't have our individual responsibilities and accountabilities and sort of levels of effort that we need to individually meet, but that almost that the reward becomes collective and exponential, rather than creating that internal culture of I'm going to do more and get more and be more than you, and which creates sort of a cultural I guess knock-on effect in terms of how it feels to be inside organizations. And I think that's true. That's not just a law firm thing or a design firm thing. That's, I think, just a work environment thing.
Yeah, and I think so yeah, sorry, Andrew, I wasn't sure if you were talking about the client work pricing models. And so for Tapestry, there hasn't been any sort of radical difference in how the client work is done or priced since becoming an EOT. So we still, you know, the lawyers still have our hourly rates. Clients are still charged with, you know, based, you know, in a similar way to the way that they were before. And I think that that's, you know, probably not so reflective of an average law firm either in the UK or in Australia. And it would be interesting to know whether there's been a, you know, significant impact on client work and how that's done and how it's charged for the other UK law firms that have become employee owned. Because, you know, I think Tapestry was, I guess, much more, it fit in much better with the structures such that, you know, the transition wasn't really radical in terms of people's day-to-day and from the client perspective as well. But I think there is flexibility where it could be, and particularly if you had a more traditional structure, then there could be a major change, and that would be something that would need to be really carefully managed. But I think absolutely being employee owned and having, you know, a range of different employees having input could definitely mean just being more dynamic and flexible and evolving a bit faster than, you know, we typically do in the legal industry.
Can I share one insight as well from my early years? I worked in a law firm, it's before joining Mills Oakley. I worked in a law firm where there were 7 partners and 50 staff. And 3 of those partners were the equity partners and the other 4 partners were not. I was a junior lawyer up to the rank of associate. And the 3 partners were continually promising the other 4 partners that they would invite them into equity. And year after year, that promise was continued to be made, and the goalposts continued to be moved. And the three partners, obviously, by virtue of my own story, made that mistake one too many times, and we all left. It's not an unfamiliar story within the legal profession. There is a lot of lateral movement. My firm is known for that in terms of receiving practices from other law firms who, have been sold a particular narrative about where their futures might lie. And we're almost a safe haven for refugee practices of commercial lawyers who've had bad experiences in other firms. And so, it really is something that I think the legal profession has a bad history of causing its own problems with, pursuant to the fact of the concentration of power and the challenge of, I don't know whether it's lawyers' personalities specifically, or it's more widespread than that, but the inability to play well with others and to share on a larger scale.
And I think it's what you start to push into then is we're not only just talking about EOTs and ownership structures. What we're talking about, is tapping into that whole concept of what is new law and what is the future of how law is practiced, and how tightly interwoven the structure of firms reflects either the culture or the constructs of what law and how it is practiced. So I think it's fascinating being outside of it and thinking about, I guess, organizations and organization structures, and how those structures both can enhance or reinforce those biases or those established norms that maybe aren't benefiting as much as they or aren't as impactful or equitable or as they may have been thought to be, or maybe
it's also generationally significant. I was in Hong Kong 7 or 8 years ago at a breakfast with about 10 of we were all managing partners of law firms globally, hosted by the Financial Times, and I was the only one, obviously, in a non-traditional model at the table there. And I was saying to them all, because they were talking about how to squeeze greater profit per equity point, and I was saying to them all, I'm sort of maybe the last of Generation Y, sort of almost not quite a millennial, but the very cusp of the end of Generation Y. And I was saying to them, I can see why you say that that's important and that aligns with where the ongoing future of business is. But I'm hearing from and observing also, people are seeing value in time, not in money. And to Jessica's point about everyone within Tapestry having a broader interest in a life beyond their career, it does play out in terms of my own observations, even within my own firm, about a limited desire for people to work towards partnership in the traditional framework. And it may be that in 10, 20 years' time, traditional law firm partnerships are a thing of the past or are no longer the norm.
Thank you for that. It's really important. And some questions have come in around what kind of trust is typically used. And I believe it's a discretionary trust. Is that right, Andrew, for EOTs?
Absolutely. The way I was express it is a discretionary trust on steroids. And the steroids are ostensibly those matters which are seek to provide prudential protection to the tax system, but being put bluntly, that the employee ownership trust is not rorted for tax purposes.
Great.
So these are matters that constrain the operation of a conventional trust.
And the beautiful thing around, moving beyond even the tax structure of, or even just the legalities around trusts and how they're used, the role that the trust plays and the trustees play is a real sort of guiding and, I guess, governance and overseer of, is the business, is is the operating company actually doing things and making decisions for the benefit of employees? And so I think it becomes a very beautiful dynamic. It's not a policing dynamic. It's a very much an encouraging dynamic. So yes, there's that's to the functional part of, yes, it holds the shares, but also the cultural part, that the role that trust and the trustees play is really quite pivotal. And just another question that's come in is around, are the distribution models, how are the distribution models set out within the EOT for the different levels of employees? And is it performance-based only, seniority, longevity of employment? And how is the difference received by them at recruitment stage? I'll just say high level and broadly, you really get to make the decisions on how that profit is distributed. MELD chooses to do it evenly. We divide 25% of our profit across everybody evenly. And so we haven't created duration of employment or anything like that. But I know lots of other organizations do use different percentages of, like, the percentage of your salary from the pool of salaries is the percentage of the bonus that you will get. Curious how that plays out for you from your observations at Tapestry, Jessica. And I guess just as one example of maybe how that plays out and how that's taken.
Yeah, so yeah, again, as Jenna said, there is a lot of flexibility in how that's done. For Tapestry, there hasn't been a radical shift. There's an overall remuneration policy, so people have their sort of, market salaries, and then there's a I think pre-EOT, Tapestry was, again, maybe a little unusual in law firms in that it paid bonuses to all staff, not just to the fee owners. So of course, in a typical law firm, the partners will share in the profits, and then there'll be a bonus pool which is paid, and I think that's primarily based on billable hours. So Tapestry did pay a bonus to all staff, and that's based on total contribution, and there's a number of headings that are looked at for that, and my understanding is that's remained the case as well with EOT. Of course, there are opportunities for greater reward and remuneration. Some of the profits go towards paying back the founders the purchase price, and that will continue for I guess a number of years since the transition. But I think the way that the profits are distributed after that, I think that that's something that's really open to evolution as well, and that will change as they move past the point of paying the founders, as the business expands, and there's a lot of flexibility with that. In terms of the question of how is the difference received by staff at the recruitment stage, not being involved in recruitment, it's not something that I can answer, but I can say that, since in the last 2 years since becoming an EOT, some really fantastic team members have joined, and that Tapestry has really wonderful retention as well. So I think it's, sort of, Luke talked about a lot too. It's not just client perception that you might need to come up against, but also staff perception of, is it someone who wants to work really hard for 20 or 10 or 20 years and become an equity partner, or is it someone who is open to a different model? I think it's very appealing becoming an owner from the start. But then I guess you have a different, maybe you'd envision a different career path than how that would turn out if you stayed with an EOT. And I think that is going to be generational change too. And I think there are, the newer generation is much more interested in, as like I said, valuing time and not just money, but and a balance of them both, a balance of reward in all areas, I guess. So I think it has been really positively received, and I think there's a lot of flexibility in how that would actually play out as time goes on. I think it's going to be continually refined over the coming years.
I think that's a great note, I think, for us to start to close this conversation on. I just want to thank Jessica and Luke for your time and your passion and your reflection on what this might mean in the Australian context, and for sharing those experiences that you have been having and observing. Jessica, I think it's really important. And I think as we keep moving forward into how, what are the possibilities for employee ownership by trust in the Australian context, it's really important for us to continue to have these conversations of what might this look like in different industries. You know, we're having conversations with people, with organizations that are hospitality, professional services, design, architecture, law, health as well. And I think there are commonalities across all of these things, which is really around how do we want to be operating as organizations, and what does it mean to provide that equity and access and influence, and in sharing and direction making and decision making with the people who are creating value within these organizations. And so thank you all for participating. If there's any questions that you have around EOTs, please feel free to reach out to EOA. We have a lot of information on the website just to give you a bit of a primer on EOTs and what that might mean. But really looking forward to seeing what's possible for law firms moving forward with EOT. So thank you all for your time.